Thank you very much, colleagues. So yes, as I've mentioned, this is the 7th in a series of webinars organised by the Global Coalition on Deinstitutionalisation, entitled From Words to Practice. And the two topics that we will be looking at today, which are covered in chapters 5 and 9 of the DI guidelines, are on legal and policy frameworks and on remedies, reparations and redress. Next slide, please. We have closed captioning available for this session. This is automated captioning. You can reach the captions by clicking on the closed caption Zoom menu button, and then you'll be able to view those captions. If you would like to increase the font size, please click on the subtitle settings and move the slider to adjust the caption size. To view the transcript, click on Show Full Transcript. Next slide, please. We will also have opportunities in the middle and at the end of this session for some questions and answers. If you'd like to ask a question after the presentations, you can do this in 3 ways. The first and best way to do this is to write your question in the Q&A box. Secondly, you can ask a question in the chat box. And thirdly, you can raise your hand and then you will be invited to unmute and speak. Next slide, please. Here are a few tips that we ask our speakers to bear in mind and those who intervene. Please say your name and organisation when you speak. Please try to use plain language and avoid jargon if you can. Please keep your microphone muted so that we don't have background noise. Keep your points as short and clear as you can. Please be respectful of one another's time and the time periods you've been asked to speak. And please do not use acronyms. Next slide, please. I'm absolutely delighted with the incredible speakers we have with us today, and we'll briefly run through the agenda. In the first part of the webinar, we will have 4 speakers in total. Firstly, my colleague Shandor Gurbay will speak about enabling legal and policy frameworks and the aspects set out on this in the guidelines. We will then hear from some leading proponents of the guidelines and their experiences around engaging with legal and policy frameworks. Hanbyul Choi on behalf of the Asian Coalition on Deinstitutionalisation and the Korean Disability Forum. Priscilla Rodriguez of the Inter-American Coalition on DI and Disability Rights International. And then from Robina Alambuya from Transforming Communities for Inclusion. Following this, we'll have a short Q&A and we will move to our second session at 3:15 Geneva time, where we'll be inviting Tina Minkovitz from the Center for the Human Rights of Users and Survivors of Psychiatry to discuss deinstitutionalization as reparative justice. We will then move on to hear from Diana Scheinbaum from Documenta and a representative of the author of a complaint to the CRPD committee who will speak about remedies and reparations, drawing on their experiences of the Arturo Medina Vela case. We'll have another short opportunity for some Q&A, followed by some concluding remarks, and we'll close by 4 p.m. Thank you very much to you all for joining. At this point, I'd like to move us straight into the first panel of speakers on legal and policy frameworks. And I'd like to invite Shandor Gurbay, my colleague, to give the first presentation. Shandor, the floor is yours.
Thank you so much, Stephen. Then I'm also very glad to be here on this panel. I'm just sharing my screen, just a second. Okay. So So chapter 5, I will talk about chapter 5 in a nutshell. Um, so this chapter of the DI guidelines deals with enabling legal and policy frameworks, and it has 3 subchapters. And I prepared this slide to help us seeing this chapter. This is the structure of chapter 5. And what I can initially say is that in line with the CRPD, states should repeal laws and regulations and modify or abolish customs and practices that prevent persons with disabilities from living independently and being included in the community. That's the main message of this chapter. And legal and policy frameworks should enable, of course, the full inclusion of all persons with disabilities and guide the institutionalization processes towards the closure of all institutions. As you can see on the slide, the first aspect of this chapter is an enabling legal environment. So an enabling legal environment for the institutionalization includes legislative recognition of the right to live independently and to be included in the community for all persons with disabilities. It should, of course, also include, which is very much linked to this right, to the specific right, include the right to legal capacity and legal capacity law reforms. For example, guardianship regimes and forced mental health treatment should immediately be replaced by support that persons with disabilities may require to exercise their legal capacity. The second right in the row is the right to access to justice. So persons with disabilities placed in institutions face environmental, attitudinal, legal, communicational, and procedural barriers to access to justice. These should be removed across all legal domains. This is the message here of the guidelines. So, for example, recently, the European Court of Human Rights condemned Hungary for failing to protect the lives of institutionalized persons with disabilities. This judgment sends a strong message against institutionalization and guardianship regimes. As a human rights organization dedicated to the fight for the rights of persons with disabilities, Validity was granted standing to pursue the case, although we didn't have a power of attorney, because Validity was denied entering into the so-called top house institution to provide legal services for persons with disabilities. Ms. TJ was denied exercising her right to access to justice, and her horrific treatment in the institution resulted in her death at the age of 45. The guidelines underline that where children or adults are in institutions and are unable to file complaints themselves, national human rights institutions, NHRIs, and advocacy organizations may be authorized to take legal action. The next right in the law is the right to liberty and security of the person. All legislative provisions that authorize the deprivation of liberty or other restrictions on the liberty and security of the person based on impairment, including involuntary commitment and treatment, should be repealed. The guidelines also make it clear that institutionalization on the basis of disability, separately or in combination with other grounds, amounts to a prohibited form of discrimination. This should be recognized in law. The second aspect, which you can see on this slide, is the legal framework, and resources. So concerning the legal framework and resources, the guidelines point out 5 important steps for states to take. These are systematically reviewing and harmonizing legislation with the CRPD, proper mapping of existing institutions and funding currently going into these institutions. Similarly, in line with the will and preferences of the individuals, their networks and important relationships should be mapped to inform their moving into the community. It should be also highlighted that funding for institutions should be reallocated to services that respond to the expressed requirements of persons with disabilities. Existing community-based services should also be comprehensively mapped. Services that are segregated, medicalized, or not based on the will and preferences of persons with disabilities should be discontinued. These segregated services include, for example, daycare centers or sheltered employment for persons with disabilities. States should also identify gaps in support for persons with disabilities, and new service structures need to be developed. Finally, states should map the workforce in relation to deinstitutionalization and should establish priorities for improvement, assessing the feasibility of workforce transformation to ensure CRPD compliant services. The guidelines are clear that those responsible for human rights violations should not be licensed to provide new services. And now I turn to the third aspect, which is the institutionalization strategies and action plans. These strategies and plans should be structured and comprehensive with timelines, benchmarks, and proper human, technical, and financial resources. These should be prepared, reviewed, and evaluated in consultation with persons with disabilities, especially survivors of institutionalization. So that was, I think, very briefly the message of chapter 5 of the guidelines. So that's the message in a nutshell. Thank you so much.
Thank you very much, Shandor, for that comprehensive overview, and also the range of really clear recommendations that have been provided to states to ensure that enabling legal and policy frameworks are put into place. So now we're going to hear a little bit about how these guidelines have been used by some distinguished advocates around the world. I'd like firstly to give the floor to Hanbyul Choi from the Asian Coalition on Deinstitutionalization and the Korean Disability Forum. Hanbyul, it's a joy to have you. Thank you.
Not hearing you. You're muted.
Yeah,
Yeah.
it's better.
Sorry, good. So again, hello to everyone, colleagues and friends. I am Hanbyul Choi from the Korean Disability Forum, KDF. So as you may know, South Korea was one of the first countries to receive concluding observations based on the guidelines on deinstitutionalization from the UNCRPD committee. So while the committee not only emphasized the guidelines, but also highlighted the urgent need for implementing its recommendations on deinstitutionalization, the Korean disability community had hopes for significant changes within our country. Korean disabled people's organizations collaborated with the lawmakers to draft bills for the Act on the support of deinstitutionalization and an act for redress of deinstitutionalization survivors of institutionalization. So we could meet allies for deinstitutionalization in and out of National Assembly which enabled us to submit the bills and to the National Assembly. But you can imagine that we faced a strong backlash. So not only did the bills encounter opposition in the parliament, but the existing ordinance of the Seoul City for supporting the institutionalization was repealed. And this was largely due to the coordinated resistance from institutions, religious groups, parents' organizations, and service providers. So even the UNCRPD committee issued a statement expressing their concern over the abolishment of this ordinance. So yes, we are now facing significant political obstacles, actually a huge one. So how can we counteract these backlashes? The government tries to avoid its to being a party here, but it should not be framed as a fight, conflict between citizens, like the persons with disabilities and their parents or the institutions. But the government, as a state party to the UNCRPD, must uphold its obligations and adhere to human rights principles. So it must make decisive and clear commitments to its obligation. But unfortunately, it seems far away to wait until the government takes its role. But not only in Korea, but also in many other countries, we hear the upsetting stories of unwilling governments, and the governments seem to prefer the status quo rather than a step forward to the future for all. So the reason why we can keep our voices loud is thanks to our colleagues.
Microphone connected.
So yeah, is it connected? Can you hear me? All right, yeah. So thanks to our colleagues, we can keep our works demanding to comply with the UNCRPD guidelines. And so we have the survivors of institutionalization stand at the United Nations, the Korean National Assembly, and in front of the Seoul City Hall. So they share their experiences in institutions with courage, which driven by their love for a society that once excluded them. So they do not want the babies with disabilities to experience the same things they did. So, and we also have colleagues connected throughout the borders. And it was really amazing that we could see that in 2022, the UNCRPD committee adopted the guidelines on deinstitutionalization. So we could see that the committee and the global disability community have come together to address the problem of institutionalization. And so the guidelines gave basis for us to speak up together, along with the convention at the UNCRPD and also the General Comment number 5. It proves the right to deinstitutionalization and independent living that we are demanding to our government is not only one country's problem, but is internationally supported and recognized. And it is a source of pride that we have each other's backs. So we are, which the guideline was not by the experts, but in colleagues with disabilities all around the world. So in celebrating the guidelines in 2023 August, the disability organizations in the Asian region gathered as an Asian coalition on deinstitutionalization. So by having conversations and understanding each other's struggles in their own countries, we are making concrete solidarity. So for example, we joined our colleagues' fight in Nepal in demanding the independent living policies and budget from their government. So we wrote letters and held press conference to urge the Nepali government to implement their obligations under the UNCRPD and the guidelines. So I'd like to end with a quote from a survivor of institutionalization in Korea, Seokyoung Moon. He said, just because we cannot speak doesn't mean we cannot feel freedom. So ask us what we need. So no one can be truly free until everyone is free. So we are here for each other, and thanks. I would like to thanks for you again for being our colleagues. And let's keep in touch. Thanks.
And thank you very much, Hanbyol, for that inspiring end, but also highlighting the crucial importance, I think, of the leadership of survivors of institutionalization in reform processes. But also, I think that you touched on extremely well the risks of backlash and political obstacles, as well as the crucial role survivors can play in drafting legislative proposals. I think it would be really interesting for all of us in this community to learn from those legislative drafts, because this can be a very powerful advocacy tool. Moving to our next speaker, I'm absolutely delighted early in the morning over there to welcome Priscilla Rodriguez, who's going to speak for us next, representing both Disability Rights International and the Inter-American Coalition on Deinstitutionalisation. Good morning to you, Priscilla, and over to you. Thank you.
Thank you. Thank you. Good afternoon over there, Stephen. And thank you to Validity and to the Global Coalition on Deinstitutionalisation for this webinar and also for the series of webinars that you've been organizing. And also thank you to my fellow panelists. It's an honor to be here with you. And for those also who are joining us today, listening in. So as Stephen mentioned, I'm talking on behalf of Disability Rights International and the Inter-American Coalition. So first, I'm going to speak on behalf of Disability Rights International. I was also asked to talk a little bit about reparations in the Americas, in the region where we are, as you know, and then I'm going to talk about a bit about the Inter-American Coalition and what we're doing in terms of the guidelines and also specific cases, countries where we are seeing some challenges in relation to the implementation. So in relation to our work in the Americas, you may know that there are regional human rights systems, and Chandler was talking about the European Court of Human Rights, and in the Americas, there is the Inter-American Human Rights System with a commission and a court. And in our regional system, for a case to reach the court, it first has to go through the commission, and the commission issues a decision, which is actually the basis for the case, for taking a case to the court. And DRI has been litigating some cases in the Americas, specifically one of a public psychiatric institution, which I cannot name right now because we do have a decision, but it's still confidential while it's being sent to the court. But this institution, is extremely abusive. There is widespread systemic physical sexual abuse, use of restraints, isolation rooms, torture, inhumane and degrading conditions, etc. So we took this case to the commission a while ago, and we finally got a decision. And the decision was issued actually after the guidelines were published, and we are proud to say that the Commission's decision reflects the guidelines as well as the CRPD in relation to the obligations to the institutionalization. So I'm just going to share very quickly the reparations that we have. Like I said, I cannot name the case right now or the country. We hope to have to be able to do so next year, early next year, and then we can share it with you. But I just wanted to show you a little bit of what the Commission is asking in this case. It's asking for comprehensive compensation, materially and immaterially. It's also asking for duly investigation of all cases of violence and abuse. It's also asking for psychological and physical and psychological healthcare with the full consent of people with disabilities, and if they so wish, and also adopt and immediately implement a comprehensive policy and effective plan for the deinstitutionalization of the people detained at the institution, including deadlines and monitoring indicators. And also, while this is being done, have a policy of non-admission to the institution and an independent mechanism that supervises the conditions of detentions in order to offer prevention and protection of human rights who are still detained. And it also talks about overhauling the guardianship regime. It talks about ensuring that it talks about reforming its legislation to ensure that it's compliant with the right to legal capacity for persons with disabilities. It talks about also creation of support systems. It talks about abolition of the guardianship regime. It talks about also how to ensure that the legal capacity of people with mental disabilities is actually a reality and people with disabilities can exercise their rights. And it finally goes into detail, and I'm not going to read this, but it goes into very specific detail into the sexual violence that happened against women with disabilities and men and girls as well, who were detained at the institution. So it took a really long time to get this decision, but in the end, we were actually satisfied that it happened after the guidelines, and that a lot of those principles could be could be part of the decision, but also of the reparations. Of course, there are challenges to the implementation right now, specifically, I mean, as Chandra was mentioning, the guidelines talks about monitoring, the importance of monitoring, and by independent mechanisms, but it also talks about monitoring by representative organizations. I think is one of the only documents that we have found to talk about actually monitoring by civil society and by representatives. And we are it's still a challenge though. We just visited the institution, and this was the most restrictive visit we have had in many years, and we are right now one of the challenges is actually going to be have individual access to each of the victims to be able to talk about individual reparations and what they mean for them. And in terms of the Inter-American Coalition, what the Inter-American Coalition did was a very general survey last year, initial survey on what is right now the situation of institutionalization in the region, and also what are the challenges. And one of the main challenges is the collection of statistics, also monitoring of institutions, and the fact that there are really no plans for the institutionalization in the region. I was just in Colombia, and Colombia is one of the first countries that's starting to design a plan on the institutionalization. Sadly, it's talking about group homes. So, well, they are looking at the guidelines, and they made sure to tell us that they were looking at the guidelines. There is still the challenge of cherry picking what they like about the guidelines, what they don't. And right now, the fact that they are talking about group homes is a big challenge. But on the plus side, they are talking about reparations, the institutionalization as a form of reparation. So still a lot of work to be done in the region, but some progress. And I think the fact that we have these coalitions that we are getting organized is empowering. I believe that if we're going to get organized to start issue a communication, start talking to Colombia about the fact that group homes are not allowed as in part of the institutionalization process, and also celebrate the successes that are being done then, and try to replicate them in other countries, specifically in relation to access to justice and reparations for those who have been institutionalized. So thank you very much.
Thank you very much, Priscilla. Congratulations to the DRI team on this, what sounds to be a very important legal development, advancing deinstitutionalization, reparations, and redress for some of victims of institutions. We will be very interested to hear more about that. But also, I think, for highlighting there the particular importance of access to justice, both for those who are currently experiencing institutionalization and those who have left institutions. This is really essential, I think, to ensure that rights are enforceable and deinstitutionalization is not just a policy objective. So thank you. Thank you very much for those important interventions. I'm now delighted to welcome our next speaker and the final speaker for this part of the panel. This is Robina Alambuya, who is representing Transforming Communities for Inclusion. Robina, it is always a joy to have you. Thank you very much for joining us, and the floor is yours. Over.
Yes, thank you so much, Stephen. Yes, and all the members of the Global Coalition. It is great every time we meet here. It's like a celebration that we are taking steps. So I just want to appreciate each one of us here and say that I do love and treasure each one of us. And I bring greetings from TCI Global, Transforming Communities for Inclusion Global. Actually, many of our members at the moment are in travel. I'm beginning my travel tonight, in the night. Others are already traveling that they have not been able to connect because we have a big conference that you are aware about, a plenary in Bangkok. So, but their greetings and their hearts are with us. I would also like to say that indeed I do honor the author of life, that I'm alive and I'm able to connect with you all. Yes, following what our previous speakers have said, I just want to bring out, with the limited time we have, challenges concerning the legal and policy frameworks in Africa. We are aware that most of the African states have ratified the Convention on the Rights of Persons with Disabilities. However, there is very limited progress in implementing the UN guidelines on the institutionalization, because the process of harmonizing the national laws and policies to the Convention on the Rights of Persons with Disabilities is still very slow and low. It is observed that mostly the disability laws at country levels are the ones where there is effort that has been put there for them to harmonize with the CRPD standards. African states still have laws and provisions in the laws that facilitate institutionalization and also discriminate and deprive the legal capacity of persons with disabilities, in particular as persons with psychosocial disabilities. For example, I'll take this example, Uganda, like a representative of one of the African countries, and somehow what is happening here happens in most of the African countries. Laws that still carry the language against persons with sexual disabilities, that demean us and bring and infringe on our legal capacity. For the case of Uganda, as I've said, do include words like mental illness, madness, imbeciles, idiots, psychiatric patients, people of unsound mind. These phrases have been incorporated in international laws and policies. For example, the section I can quote, Section 130, Penal Code 126. Others include the Trial on Indictment Act, Cap 25, the Magistrate Court Act, Cap 19, and the Evidence Act, Cap 9. Yes. So this takes away the legal capacity and negatively affects our participation and inclusion in the communities. Although some of the African states are reviewing and amending the mental health laws with the coming in force of the CRPD, still these mental health laws are medically inclined and still have a lot of gaps. They allow involuntary admissions. they allow forced treatment to persons with mental health conditions. Then we have, as in the African continent, and of course here I can refer to Uganda because here I have the real evidence, I live there. But what is happening here, as I have said, also happens elsewhere. There is very limited knowledge about the DI guidelines by policymakers and lawmakers. We were able to do a rapid, at Triumph, a local organization, which I lead, we were able to do a rapid assessment to ascertain the readiness to implement the DI guidelines by the local government of Jinja City. And we found out that many had not heard about it or heard about it, but they somehow they saw it complicated. They had not even bothered to see how to. But after talking with them, they were willing, they were saying they need more information and guidance, how exactly it is going to happen. Some doubted. There was a debate, can it be possible? But the end of that interaction with the policymakers, they said, now we need more training and information, and also to prepare the communities. Because one of the community development officers said that we need to prepare the communities before this can happen. Now, when I go, because of limited time, let's go to the opportunities that we have. So among the opportunities, we have the opportunity to do strategic legal litigation, which in Uganda has been mainly supported by Validity Foundation. Thank you so much, Stephen and team. So these strategic legal litigations do expose grave violations that happen to persons with psychosocial disabilities in the psychiatric institutions in Africa. And this provides evidence to advocate for policy, programs, and law and changes in the law that can promote inclusion and facilitate the deinstitutionalization process. Another opportunity that is there that we've gotten, for example, here in Uganda, another opportunity is challenging the national laws that fall short of the standards of the CRPD, like the case of CEHAD, that is Center for Health, Human Rights and Development, and Yiga Daniel versus the Attorney General. In the Constitutional Court, it was noted by the Constitutional Court that those words like idiots, imbeciles, are derogatory and diminish the dignity of persons with disabilities. So our advocacy, we are using that case, which was won by Yiga Daniel versus the Attorney General case. We won it, so we are using it to do advocacy. So it's an opportunity. When such happens, we can use such to do advocacy for change. Another opportunity, before we conclude, is that we have the opportunity. For example, now we have the Global Coalition on Deinstitutionalization, where we are learning from. We can encourage forming of coalitions on the institutionalization at the different levels, up to the local level. And all these will be able to cause like a united voice. We can also use media in all its forms to be able to raise awareness about these guidelines and the guidance that they are giving, and also to advocate for deinstitutionalization. In conclusion, due to the limited time that we have, organizations of persons with disabilities must meaningfully participate in all the law reforms processes and the various in the various countries. And this calls for intensive advocacy and resource allocation for the organizations of persons with disabilities, the OPDs, to be able to do that at all levels, so that we can be able to see what we want to see, so that persons with disabilities, including persons with sexual disabilities, we are able to live independently in the communities with the laws and the policies that support us. Thank you so much.
Thank you so much, Robina. And I think a really fascinating and important account there about how to fight back against discriminatory legislation, about how little awareness there still often is on the part of policymakers and decision makers of the type of changes needed. But also, I think your reflections on the role there of legal empowerment and potentially strategic litigation in pushing for some of those reforms. So thank you so much. Thank you very much for these important contributions and remarks. At this point, I want to say that we have just a minute or two to respond, actually, or to acknowledge one or two questions. And I have a couple that have arrived in the chat box. And maybe I would just like to give each of the speakers, if I may, 30 seconds each, just to briefly respond to the question, which is about whether people with disabilities in institutions can access legal support. Are they able to get access to legal support in your regions? Maybe I could ask firstly, Priscilla has come onto my screen. Priscilla, can people in your region access legal support? Thank you.
Yes, thank you, Stephen. And I think that's a great question and one of the also biggest challenges of implementing the guidelines. No, the short answer is no. We've alleged, for instance, in the case of the X institution that I mentioned, that people with disabilities in institutions are, first of all, physically impeded from accessing institutions. There is no real monitoring, independent or nor effective, of the institutions to actually gather documentation of abuses. There is they are under the guardianship of the directors, sometimes the jury by law, sometimes de facto, but the guardian, for instance, in the case of this institution, was their legal guardian, and he was also in charge of reporting the abuses. But there is the conflict of interest that has already been pointed out by the European Court of the fact that the guardian is also responsible for the abuses. So obviously he's not going to report them, and he was not reporting them. And there is also in institutions, generally speaking, a fear of a climate of fear of punishment when there are complaints being made against staff for violations. So no, the short answer is no. And yes, that is one of the huge barriers to implementation of the guidelines.
Thank you very much, Priscilla. A lot of similarities with our experiences here in Europe, and particularly that situation of conflict and also powerlessness with which people find themselves when they are subjected to both legal and physical restrictions. Hanbiol, I wonder if you have any remarks on this respect.
Just as Priscilla said, it's really similar in Korea too. So only a few people who are, how can I say, the privileged to be connected with other NGOs can reach to the legal justice. So that's why now Korean DPOs are looking for demanding the ratification of the optional protocol of the Convention Against Torture, which at least enables national preventive mechanism to independently monitor the place of deprivation of liberties. So yeah, and also we are trying to make more independent of the monitoring by the Human Rights Commission.
Thank you, Hanbiol. And finally, if we may, Robina. Robina, can persons with disabilities access legal support in your region? I don't know if we still have Robina.
Hello.
Hello.
Yes, persons with disabilities accessing legal support. Mainly the legal support has been there through civil society, mostly. Though there are some support centers that like legal aid, you find them, but most successful ones, some of the members have tried there. They have tried the different ones, but the most successful support that has gone on and has been followed up to the end mainly is through civil society. Just like I said, that Validity Foundation has been working in Uganda through Mental Health Uganda, and they have been trying to give that support. And then I've just talked about CEHAD, Center for Health, Human Rights and Development, that supported the Daniel, our peer, a person with psychosocial disability, when he was when he decided to put a case with the Constitutional Court, they joined. Then we also have Bedoni Kabale case, because of what he went through in the institution, seclusion. That case has taken years, and it is still Validity Foundation and maybe some other people have tried to come in to see that there is justice. But that's what I can say. Most of the legal support has been with the support of civil society organizations that have come in to support. Yeah, that's what I can say at the moment.
Thank you, Rubina. And clearly there is a need for significant investment so that people with disabilities can access independent legal support, so that it's not dependent on a few actors and a few connections. Clearly, this is one of the important points, I think, that we can collectively stress the need for independent access to lawyers. So thank you, and thank you to all of the speakers in the first part of this session. We're now going to move to the second part of the session, where we will have two excellent speakers. The first, it will be now Tina Minkowitz, who is representing the Centre for the Human Rights of Users and Survivors of Psychiatry. And she will take us through deinstitutionalisation as reparative justice. Tina, thank you for joining us.
Thank you, Stephen. So as some of you may know, that is actually the title of a paper I've written. So I encourage you to look for that paper and take a look at it if you want to get that more comprehensive information. I'm going to first share a screen with the forms of reparation in international law. I'm going to be referring to some of this throughout the presentation, and they're not exactly listed in the guidelines. Some of them are referred to, but they are implicit throughout, and it's part of the general framework that the guidelines makes reference to, that these forms of reparation are addressed in all of the other documents, really, that the guidelines section on remedies, redress, and reparations refers to as the foundational documents. So oops, that's not what I wanted to do. I wanted to keep this up, actually. But I want to, well, I don't know how to do that. I've got to go to my presentation that I'm going to read from. So I'll see if I can do all that at the same time, maybe not. Okay, so what does it mean to approach deinstitutionalization as reparative justice? So I would start with the point that the concept of deinstitutionalization has a lot of baggage from the past. Traditionally, it was service provider driven and assumed the incapability of the people who have been victimized by institutionalization. It assumes institutionalization was meeting a need, and now we're deciding to do it better. Deinstitutionalization as reparative justice comes from a belief that there was never a need of anybody to be institutionalized. It has always been unjust, and we have to reverse that injustice by freeing everyone and assuming their inherent capacity as human beings to make choices about their lives. This relates to the reparations framework concept, and I'll see if I can get it again, of cessation of violations. I think it's going to be too hard. I should have given that to somebody to do for me. Here it is. Okay. I think if I don't put it on the slideshow, that's how I can do it. So cessation of violations. We need to identify accurately what is the harm we need to end in order to formulate the obligations of states parties on how to end it. So under the guidelines on deinstitutionalization, there is an immediate obligation to revoke all detentions and allow everyone to leave immediately if they wish with emergency assistance, and to end all new detentions and placements. That is, from my point of view, a reparative concept emphasizing the cessation of violations as an immediate obligation. It's important to note there are different kinds of institutionalization, and all must be ended. Long-term, but also short-term, statutory detention with no right to leave, such as psychiatric detention, and also the kind of institutionalization that's about practical impediments to leaving because of lack of the needed support or needed medical equipment or assistive devices, and also poverty as causes or of institutionalization. There are also step-down kinds of institutionalization left over from the older approach to deinstitutionalization, such as group homes, halfway houses, some places that call themselves independent living centers or supportive housing. They're controlled by service providers with many restrictions of freedom and lack of privacy that qualify as institutions under the DI guidelines. So all must be ended. This is also an important reparative element to pay attention to not allow any piece of the framework of institutionalization to remain. There's a need to consider how people are harmed by institutionalization and what survivors need to repair that harm in their lives. Only by reflecting on the harm and the needs involved from survivors' perspectives can we make an agenda of what actions to carry out. The DI guidelines does this as a beginning, and it needs to be fleshed out and tailored to specific situations and countries, and even for individuals. Nothing can either compensate or change the impact of years lost to institutionalization and/or dealing with its aftermath, the severe discrimination entailed, and how it affects our relationships with other people and ourselves, and with life in general. There are irreversible effects of electroshock, neuroleptic drugs, and psychosurgery that we have to work with ameliorating and accepting or coping with as survivors. Neuroleptic drugs are the most commonly used of these measures that have irreversible effects. We can also mention lithium, benzodiazepines, and many other psych drugs. Neuroleptics have the distinction of being recognized as a torture drug used on political prisoners with the same effects as any ordinary folks in the psych ward. In particular, akathisia, which is a restless disturbance of mind and body, and psychic apathy or indifference. These drugs have long-term effects that are not yet adequately studied or ameliorated. Also, the gaslighting is something we have to deal with. The cover-ups and paternalism that demand we suppress our knowledge and experience of the trauma, that we act grateful and cooperate with it, and we're punished with more for resisting. All this takes a huge toll on our energy, health, ability to have peace of mind, even long afterwards. These harms and others need to be made widely known and fully explored as to what remedies are needed. The DI guidelines provides a template for both systemic measures to remedy the harm caused by continuation of institutionalization and the conditions that create vulnerability to institutionalization and other human rights violations, and individualized measures for leaving institutions and reestablishing one's life in a community. Instead of treating people in institutions as having deficits that made others decide to institutionalize them, or that were created by institutionalization, we need to honor survivors for the choices they have made under impossible circumstances and work towards reestablishing just relations between society and all survivors of institutionalization. This understanding needs to inform all systemic and individualized measures. Survivors may need support to leave, whether economic, social, or otherwise. For example, identity documents, help finding housing, money to live on, information about educational and work opportunities, and connections with community. And the DI guidelines provides for all of that, at least in some degree. And note, in order to avoid continuing institutionalizing and coercive relationships, the support that's offered to people in leaving should not come from those who have perpetrated institutionalization. A reparative approach is not the same as mental health discharge planning. Support should be responsive to the person's actual perspective on the resources they need and do not have, rather than trying to plan out somebody else's idealized vision of their lives after institutionalization. Economic support is crucial, especially if the person has been institutionalized long-term, has no money in the bank, etc. People may be able to rely on family and friends, but should not be required to. Those relationships might be abusive and might have perpetrated the institutionalization. This relates to facilitative measures, still, I believe, for cessation of violations. Restoring liberty and the facilitative measures involved can also be understood as restitution, and some of it people might want to understand as habilitation or rehabilitation in terms of the services people may need to have access to in order to create the life they need in the community. Systemic obligations include changing the kinds of services and supports available so people will not have to return to institutional service providers, and we can eliminate institutions and institutional type services, coercive, segregative, and medicalized, without fearing people will be left stranded. There are huge questions about what that means in relation to changing practices in the mental health system and/or creating and strengthening alternative forms of support and services outside the health system and without requiring a psychiatric diagnosis. People with psychosocial disabilities and survivors of psychiatry from diverse regions have all agreed we don't want our lives, human rights, or support needs to be put under the mental health system's authority or under a right to health. The DI guidelines prioritizes and emphasizes demedicalized supports and services in multiple ways, and I see this as reparative because it's responding to survivors' perspectives and identified needs and priorities. There's an obligation to eliminate services that are segregative, coercive, or medicalized. The mental health system is not to provide housing, and housing cannot be bundled with services. The guidelines declare that individual crisis is not a medical problem requiring treatment or a social problem requiring forced intervention. There's an obligation to provide service options outside the health system without a mental health diagnosis to meet needs related to distress or unusual perceptions, including crisis support, decision-making support, support to deal with trauma, and to find solidarity and companionship in the community. The guidelines promote autonomous peer support to meet many needs of survivors. There's an obligation to make all parts of community and mainstream services accessible, welcoming, and responsive to the needs of survivors, no exclusions based on mental illness, the perceived extent of needs, etc. And healthcare services are obligated not to embed the medical model of disability. And all this needs to be addressed to create a large-scale approach that I would argue has to be done with funding not tied to the mental health sector, which could be a money follows the person approach so as not to be tied to any other problematic sectors. So these measures, along with law reforms that have already been mentioned, relate to guarantees of non-repetition, which is another hugely important element in the reparations framework. And survivors have emphasized that as really the most important. If you don't take away the mechanism for the violations and remove the fear of them happening again, survivors are not left with very much. It will keep happening, essentially. So it's not meaningful. I want to lastly touch on the obligations to create reparations mechanisms and also systemic planning. Systemic planning and implementation of deinstitutionalization includes all the systemic obligations like law reform and how it will be done on the ground, supporting individuals to leave and ensuring compliance with the obligation that they be allowed to leave. This is another aspect of cessation of violation, the obligation to actually take effective measures to end institutionalization. Designated reparations mechanisms and processes can support deinstitutionalization in some various ways. They can help to identify the scope of institutionalization and the nature of harm in the particular country beyond what the guidelines already specify. They can establish a record with which to raise awareness about the injustice committed towards people with actual or perceived disabilities and the common ground of humanity from which to move forward, not only for people with disabilities, but for everyone. Also about the strength and knowledge of survivors and their contributions to society, the meaning of institutionalization experiences in our lives, and the lessons learned and the strengths gained from surviving. They allow particularization of measures that individuals may need as support or compensation or recognition relating to the harms they have suffered. And yes, I'm trying to finish up. For instance, on regaining custody of children, or if people lost their memory to electroshock or have tardive dyskinesia, etc. Survivors may need multiple spaces to share their stories and to have the choice of whether and how to address perpetrators. There should be national and subnational truth commissions centering survivors' stories and accountable to survivors for creating a record and a process that's welcoming and comfortable and respectful to them. Apology is also part of the element of satisfaction, formal recognition that violations have occurred and their commitment to prevent them from happening again. States and international tribunals should hold perpetrators accountable, and we need to analyze and understand what's the best way for this to happen, whether we want to pursue criminalization of institutionalization and forced interventions. Criminalization of torture is already an obligation in international law. So I'm going to end there and Thank you for your time.
Thank you so much, Tina. I mean, an incredibly detailed but also comprehensive analysis of the reparations framework as it applies to the historic injustice of institutionalization of persons with disabilities. And I think it really pushes us to move beyond these sort of reformist impulses where we see that those who are responsible for historic harms often propose simply cleaning up institutions, making them more humane, making them a little bit friendlier, but actually are not getting to grips with the historic nature of the content of the violations that have occurred and the systemic aspects which have enabled those to continue today. And also, I think really setting out for us a pathway that can help instruct and inform our collective advocacy around this issue, not simply calling for apologies, as important as those can be, but really forcing us to look at both individualized and collective forms of redress and remedies that are necessary to not just repair harms, but also come to grips with those harms publicly so that they can't be repeated in the future. So thank you so much, Tina. A really hard job to do that in 15 minutes. Congratulations. And also your article contains much further analysis as well. I'd like now to move to our final speaker of the day before we open for a short final session of Q&A. I'm absolutely delighted that we also have with us Diana Scheinbaum from Documenta. And Diana, you've also engaged and worked around remedies and reparations for survivors of institutionalization. It's a pleasure to have you with us. You have the floor. Thank you.
Thank you very much, Stephen. Thank you to the Global Coalition for this invitation. I'm very happy to be here today and share the experience of Documenta representing Arturo Medina's case before the Committee on the Rights of Persons with Disability. This was the first case, the first Mexican case before the committee. I wish Arturo could be here sharing his experience, his personal story. He couldn't attend to this seminar, so I'll try to share from Documenta's experience two things. First, what happened to Arturo, and then to reflect with you on what did the committee resolve on his case and what changes, what have been the changes and challenges in the legal and policy framework, which is the theme that brings us together today. So Arturo was detained when he was 21 years old. He was walking down the street and the policeman accused him of trying to steal a car. They took him to the police station, and after more than 10 hours, Arturo's mother appeared in the station and told the police that Arturo didn't know how to drive. And she also submitted some documentation attesting to Arturo's disability. So at that point, the account of the bands changed, and the police said that Arturo was not trying to steal the car by driving it, but by pushing it, right? And there were a lot of contradictions in the statements of the police officers that arrest him. Arturo went to a psychiatric evaluation that determined that he had, and I'm going to use the terms used by the psychiatrist, right? That he had antisocial personality disorder and a slightly mental retardation, right? Those were the terms used by the psychiatry. So at that point, a criminal process started against Arturo, and he was detained at a prison for men with psychosocial and intellectual disability that is placed in Mexico City. So during the criminal process, Arturo was found not criminally responsible. And for him, that meant that the criminal process took place without him being able to participate. He tried to change his public defense lawyer. He couldn't do that. He couldn't present any evidence that support his case. Sometimes he wasn't even present at the hearings. He wasn't personally informed of the judicial resolution. He was stripped of his legal capacity. He had no accommodations or support in the criminal process, and he was deprived of his liberty based on his disability. The judge determined that Arturo was to be deprived of his liberty, and he imposed a 4-year sentence, right? Arturo was in prison for 4 years. We first litigate this case, nationally, and then decided to take the case before the Committee on the Rights of Persons with Disability. And, for a couple of years, for many years, we exchanged information between the committee, the states, and Arturo's representative. And finally, 4 years after the individual communication was presented, the CRPD published its resolution. What did the CRPD resolve? It determined that the Mexican state had failed to fulfill its obligations under several articles: Article 5, equality and non-discrimination; Article 9, accessibility; Article 12, equality before the law; 13, access to justice; and finally, Article 14, liberty and security of the person. And what I want to share with you is the actual recommendations of the committee. So the recommendations are divided into 2 parts. The first one concerning the author, concerning Arturo, and then the measures of non-repetition. So concerning Arturo, the CRPD said that the state had to provide him with an effective remedy, including the reimbursement of all legal costs, together with compensation, right? So what the state did was to financially compensate Arturo, but there were no rehabilitation or habilitation measures for him to be able to reintegrate the community, to reestablish his relationships, and to secure his access to all rights. So the remedy in this case was really restricted to financial compensation. The committee also suggested or recommended the state to make a public acknowledgement of the violation of Arturo's rights and adopt any other appropriate measures of satisfaction. So Validity has helped us to share with you a short video of the event where the state actually did his public acknowledgement, and Shanji will try to put it on the screen. The video has English subtitles. Thank you for that. I know there was no sound. We couldn't hear it. The sound, it was actually in Spanish. So I hope you got to follow the subtitles. In summary, the representative of the state actually, publicly apologized to Arturo for the grave human rights violation he had to endure. The representatives talk about the degrading treatment, the lack to access justice, the lack to legal capacity, and how Arturo and many, many more people with disability confronted these violations on a daily basis. And he actually made a commitment to transform the legal framework to guarantee the rights of persons with disability, particularly in those areas, legal capacity and access to justice. So besides the public apology, the committee also included in its recommendations that the present views of the actual resolution were circulated in accessible formats, so they are available to all sectors of the population. Let's focus now on the obligation to take measures to prevent similar violations in the future. So I want to address each of the 4 recommendations regarding non-repetition and tell you what has changed and what are still the challenges. So the committee recommend that in close consultation with persons with disabilities and the organizations that represent them, that the state make all necessary amendments to the criminal law regarding the exemption from criminal responsibility, with a view to bring them in line with the principle of the convention and ensuring respect for due process in cases involving persons with disability. I want to share with you that until this moment, that change has not happened. The criminal legislation that was applied in Arturo's case is still the same legislation, and is the legislation that disproportionately impacts persons with psychosocial and intellectual disabilities when they are accused of committing a crime. The committee also said that the state had to review the application of security measures involving the committal for the purposes of medical and psychiatric treatment and take the necessary steps to promote alternatives in line with the principles of the convention. Again, after many years, more than a decade, this has not happened. So persons with psychosocial and intellectual disability who are found not criminally responsible are subject to these security measures that entail for psychiatric treatment. So as you can see, Arturo's Medina case, at least regarding criminal legislation, has not entailed the actual implementation of non-repetition measures by the states. We are now at this point, Documenta has brought another case to the Supreme Court. It's not an individual case, but it's a case where Tina and other members here also help us draft some experts' opinion. It's a case regarding the actual law. So what we're saying right now is that the law contradicts the CRPD and there's an obligation to change it. Regarding the last 2 recommendations of the committee said that the state had to ensure that persons with intellectual and psychosocial disabilities are provided with appropriate supports and reasonable accommodations to enable them to exercise their legal capacity before the courts. And I think here it's probably where the most progress has been made, not in the entire country, but what we're seeing is that there are some courts that are implementing some programs and are trying very actively to offer, and to implement procedural accommodations in the cases where a person with disability is in conflict with the law. But I don't think that the judicial power sees really this as an obligation, right? It's not something that has been implemented nationwide. And finally, the committee talked about, the regular training to the judges, to judicial officials, to public prosecutors and public servants regarding the convention and its optional protocol. And I think here, again, I think there hasn't been nationwide efforts, and now in Mexico we are confronted with a very recent judicial reform that will modify all courts, because we are electing by popular vote new judges, magistrates, and ministers for the Supreme Court. So the advance and the progress that had been made with previous judges will represent a very important new challenges, because, as I said, new judges are coming to the courts. So as you can see, I think, we've encountered a lot of resistance in terms of changing the legislative criminal framework, but there has been very important changes in other aspects. For example, in the last years, a coalition of persons with disability, users, survivors of psychiatry, DPOs, and human rights organizations have been really advocating for changing the legislation, the civil legislation regarding guardianship, and there has been a big achievement in that area. Now in Mexico, we have a national procedural code that recognizes the legal capacity of all persons, including persons with disabilities, and the right to support in that regard, right? And also a coalition formed by almost the same organizations and individuals was actually able to make a reform on the Health Act, and the Health Act since 2022 prohibits all involuntary treatment and institutionalizations. So we have been pushing to create, an adequate legal environment, but what we're seeing right now is, the difference and the gap between the words and the practice, right? So we have now a civil law that recognizes legal capacity, and we have a health law that prohibits institutionalization, but every day we're still seeing people stripped of their legal capacity, people deprived of their liberty in institutions, psychiatric institutions, and also in jails. So what we learn is that, there's law reform and strategic litigation is no reform. And we actually need to invest ourselves in creating a strong movement to put enough pressure to the states and actually to force them to make structural changes. Thank you very much.
Well, thank you very much, Diana. What an incredibly important precedent the case before the CRPD committee sets, but also clearly a single case alone can't prompt all of those reforms that are so essential. And I think you've reminded us really that we need to use multifaceted strategies of litigation, of advocacy, and really of framing our requests for remedies and reparations far beyond just those of the individual cases. The Arturo Medina Vela case gives us hope that some of the wider systemic reforms, to which I think Tina spoke so eloquently, are necessary actually to prevent the recurrence of future harms, but also to transform the dialogue around deinstitutionalization away from simply providing compensatory damages towards the much wider legal and structural reforms necessary to achieve real change. So at this point, I'd like to just invite all of our speakers, if you are still with us, to put your cameras on. We've actually rapidly run towards the end of this session, but it has been an incredibly stimulating session, learning from the experiences of human rights activists, disability rights activists, and those of you from around the world who are taking on the challenges presented by the DI guidelines. and using them to advocate for more conducive legal and policy frameworks, but also, I think, reminding us of the challenges and how far we have to go. It has been an honor and a privilege to have you all with us. Out of respect for the rules, which I said myself at the beginning, and all of your time, I would like us to finish on time by thanking you, by saying that this has been the 7th in the series of webinars on the guidelines organized by the Global Coalition on DI. We do have an 8th that will be coming, we expect, during December, to be led by our distinguished colleagues at the International Disability Alliance, who are also members of the Global Coalition on DI. And we very much hope to continue our discussions in January, where the Global Coalition will be, I hope, organising a listening session to all of the participants, to everyone who has been involved in this dialogue over the recent months, as we continue our collective efforts for seeking full implementation of the guidelines, but also, of course, Article 19 of the Convention. With that, I thank you all and wish you a wonderful day, night, or rest from here on, at least a rest before you move on to what's next. Thank you so much. Thank you.
Thank you all. Thank you, Stephen.
Thank you.
Thank you very much. Bye-bye.
Thank you.